Thank you, Ashley. Thank you to the Springfield Armory National Historic Site for uh, giving us such a treat. Um, Our next panel is it's entitled The Colonial Militia, and we'll be covering several different aspects of the militia. Our first speaker will be Alex Cain, or Alexander Cain. He has a JD from the New England School of Law and a bachelor's degree in economics from Merrimack College. He authored We Stood Our Ground and I See Nothing But the Horrors of the Civil War, which is the best book titles I've ever heard, I think. Focusing on the American Revolution and New England Loyalist refugees. Alex, I'll refer to you.
How is everyone? Good, excellent. So when I was asked to present at this particular lecture, my area of research is really unique in that I've really taken a deep passion towards 18th century militias with a focus on Massachusetts militia. And within that, basically the logistics or the logistical operations in preparing for war with England. So today what I'm going to be discussing is essentially what is going on in Massachusetts on the eve of Lexington and Concord, and what are the various towns and militias within those towns and minute companies doing as they prepare for this build-up of war. In order for us to understand why the various communities within Massachusetts did what they did, a lot of times they say, well, it's because they fought because of representation or taxes. It was much bigger than that. The revolutionary movement in Lexington on the eve of April 19, 1775, goes back to this concept of English liberties. And English liberties is a long, evolving concept throughout the 17th century and before the 17th century. But basically, how it is relevant to Massachusetts is in 1688, when James II was deposed as part of the Glorious Revolution. And at the same year, William III assumed the throne. In 1689, Parliament organized a constitutional convention to identify what were the abuses of James II and to determine what were the full rights of Englishmen. And what resulted from that convention was the Declaration of Rights of 1689, also known as the Bill of Rights of 1689, which was formally adopted by Parliament. And it should be noted that this Bill of Rights, in the strictest, most narrowest reading of this particular document, only addressed the rights of parliamentarians. In other words, initially in a strict reading, the common vote didn't apply. However, common English law would eventually expand and apply those various rights to the common male population as the decades went by. And of course, in December of 1689, William III formally notified Parliament that he assented to the Declaration and swore that he would abide by its expectations. And of course, where does that fall in with the English liberties? In addition to what had previously been discussed by Dr. Savage and others this morning, relative to the rights of bearing arms, there was freedom from royal interference, freedom from taxation without consent of Parliament, freedom to petition the government, freedom of speech, freedom from cruel and unusual punishment, and the right to jury trial on a capital offense. Well, where does this fall into play with Massachusetts? Well, in the 16th and 17th, well, particularly the 17th century, there is a debate early on, do the rights of Englishmen transfer across the Atlantic to the American colonists? And when we look at the Charter of 1691 in Massachusetts, this, on the eve of the American Revolution, is considered the sacred document of the colony of Massachusetts on the eve of Lexington and Concord. And again, the Massachusetts Charter of 1691 predominantly focuses on the restructuring of the colonies in Massachusetts, because up until 1691, there were actually two colonies in the Massachusetts territory, Plymouth and Massachusetts Bay Colony. This Massachusetts Charter formally merged the two colonies and included also the formal declaration that the Massachusetts Bay Colony would be considered a royal colony, which means at that point the governor would be appointed by the crown. The charter also broadened the governor's powers and established a great self-government in Massachusetts, but on royal terms. But most importantly, and this is the key phrase, the Charter of 1691 basically extended the rights of English liberties to the colonists of Massachusetts Bay Colony. So through this document, it essentially codified English rights to Massachusetts citizens. So now if we jump forward several decades, we come to the state of affairs of 1774 Massachusetts. And basically to give the 2-minute summation, in the aftermath of the French-Indian War, the English crown is in massive, massive debt. And they realize that they have to pay this debt down. And of course, they ultimately say, well, why don't we have the American colonies help us pay this debt down? Because they are the ones who benefited from the French wars. And so a series of economic measures are passed. And these measures range from the Stamp Act to the Sugar Act to the Townshend Acts. And of course, looking at Massachusetts exclusively, Massachusetts initially started with the boycotts, it continued boycotts, but you see this evolution towards violence. But you also see this common theme starting to pop up in the 1760s, where basically Massachusetts colonists are saying, listen, these various acts, because not only these economic measures, but the other riders that are included in it, whether it's prosecuting smugglers and military tribunals, whether it's warrantless searches, whether it's the placement of troops in Boston, they are seeing this as an infringement on their English liberties. And you start seeing this trend, particularly about 1768, 1769. It's in the minority at this point, where people start saying, if we have to utilize force to defend our English liberties, we will do so. And one example of a community that did that was Lexington, Massachusetts, where they passed a town resolution indicating that they will follow all means necessary to support their English rights. We'll jump forward to December of 1773. There's a little kerfuffle that takes place in Boston Harbor. A bunch of tea is dumped into the harbor, which enrages Parliament and enrages the Crown. And as a result, a series of measures is passed to punish Massachusetts for this disobedience. The common theme is they're called the Intolerable Acts, but as John Bell in his blog has indicated, they're actually, the Intolerable Acts, I believe, is a 19th century term. They were, essentially, they had a variety of bills. They were nicknamed the Coercive Acts. But what horrified Massachusetts residents is a couple of things. First of all, the Crown and Parliament shut down and blockaded Boston Harbor. The second thing that they did was they ultimately dissolved the Massachusetts legislature. They shifted, appointments of court personnel. But what horrified and absolutely set the Massachusetts countryside in motion is they revoked that charter of 1691, which, from Massachusetts' point of view, their rights as Englishmen had just been suspended. So when you're on the eve of rebellion, what essentially happens is in the tradition of Star Wars, you form a rebel government. And this is what ultimately happened, was Massachusetts, after a series of conventions, forms the Massachusetts Provincial Congress. And starting in October of 1774, the main attention at this particular point is to look at how we prepare for war with England. Because now, by October 1774, the mindset in Massachusetts is we are going to war with England. We are going to war to preserve our way of life and our English liberties. And what happens is Massachusetts Provincial Congress, at least initially, looks at its militia system as its army to defend its English rights. Because the mindset is not only are they threatening English liberties, they believe England is going to provoke a war, thereby conquering Massachusetts or all of England, and then ultimately they could become what Ireland or India was. And so Massachusetts Provincial Congress in late October of 1774 passes a resolution that says that we must consider what is necessary to be done for the defense and safety of the province. The next step that they did was they said, listen, we need to remove any loyalist officers that are within our ranks. And they passed a resolution saying we must meet forthwith and elect officers who are loyal to the Massachusetts Provincial Congress and, take over the commands of the company. And then finally, they create this resolution, we are going to form Minutemen companies. Now, if you take a look at the concept of Minutemen, this is not a new concept. The Minuteman concept goes back to at least King Philip's War, if not earlier. And the principle was that it would be within the militia, there would be a draft of volunteers that would be recruited who would respond at a moment's notice, half hour's warning, a minute's warning, etc. But what this order basically does is it orders each Massachusetts militia company to take a quarter of their soldiers and form them into this volunteer force. So in theory now, every town, and not every town did this, but in theory, every town would have at least one Minuteman company, and every town would have at least one parent company, militia company. The Massachusetts Provincial Congress took other issues as well. And they said, in order to prepare for war, basically they said, listen, we have to treat this threat seriously. And they passed a resolution, which is behind me, that says that they must take necessary steps to prepare themselves for proper military skill, which means they need to start inspecting their soldiers of their respective militia companies. They need to start assessing what their arms and equipment are, and they have to take whatever steps are necessary that if they feel that at the time of war, they will be able to do so. And of course, what happens is, excuse me, I want to back up for a second. What happens is you see in November of 1774, this massive movement throughout Massachusetts where various towns are ordering their militia companies and their slowly promoting Minuteman companies to start inspecting arms and equipment. And there seems to be during this time a little bit of debate, what should we have for arms and equipment? And so by December of 1774, the Massachusetts Provincial Congress issues an advisory. And the advisory is that if you are going to field, particularly your Minuteman companies, you should field in times of alarm, emergencies, threats of war, that you should field with an effective firearm, a bayonet, a pouch, ammunition pouch, knapsack, and 30 rounds of cartridge and ball. So what you're going to see here as we're going along is the Massachusetts Provincial Congress, and of course the Provincial Congress is doing a little bit on its own to try and acquire arms and supplies, but there's this decentralization movement that's taking place within Massachusetts, where the instructions, what to do and how to prepare for war, are going down onto the town local community level. The final thing that the Massachusetts Provincial Congress discussed on October 29th of 1775 is what drill should we use? Because this perception, if you take a look at modern movies and films and stuff like that, there's this belief that basically, hey, everyone just grabbed a gun and ran towards the river, like Lexington and Concord, and they hung, hid behind trees and walls, and they never fought. The reality is the Massachusetts Provincial Congress took great lengths to discuss in great detail what should we advise our militia companies, this future Massachusetts Grand Army, what should they utilize for a drill on the field? And there was some debate that they go back and use what was the official drill of the colony before this crisis, which was the Norfolk drill from 1757. This very complicated, crazy drill. And then we have another gentleman, Timothy Pickering, who was from Salem, Massachusetts, kind of sort of plagiarized from the Norfolk drill. He comes into the Provincial Congress and he says, hey, I drafted this new drill. We should have got my new drill and we'll sell it to everybody. But what's really interesting is the Massachusetts Provincial Congress passed a resolution that they were going to adopt the method ordered by His Majesty in the year 1764, being, in the opinion of this Congress, best calculated for appearance and defense. That is what is nicknamed the Crown Manual. It is the same exact drill as the British Army. So the Massachusetts militia forces are now adopting the same drill. So now this gets to the point of everything's now becoming decentralized towards the various towns. How did the towns react? Well, we see basically three types of town resolutions come out. So every town is now basically issuing their own resolutions from town meetings or selectmen orders saying, this is what our militia and our Minutemen should deal with when they go to war. The first type is very vague. There are some towns that were issuing very vague resolutions that sort of look back to existing Massachusetts laws. The second one, in the majority, and I have sitting in my Google Drive, if anybody ever wants a copy of it, I have roughly about 150 resolutions throughout the years from the Massachusetts Bay Colony outlining mostly highly detailed resolutions, including arms, equipment, what they should carry, how they should respond. And then, of course, I also have resolutions, which I'm not really going to discuss today, about independent companies. These are sort of paramilitary organizations, mostly made up of the wealthy elite, with a part of their founding contracts. They outlined in it what they would have to field. I have here a couple of examples that you can see of vaguely worded resolutions. The first is from the town of Amesbury, Massachusetts, which is where I live. I live in a neighboring town, but at the time it was part of Amesbury. And they basically voted that as a Minuteman company would be responsible for its own arms and equipment. You have to supply yourself. Boxford issued a vaguely worded resolution only saying to arm and equip and hold themselves in readiness to march in any emergency in defense of the province. No guidance. Newburyport sort of a mix between vague and detailed. Newburyport basically voted that all the inhabitants of this town be desired to furnish themselves with arms and ammunition according to law, but they also, this is where they get specific, also have bayonets fixed to their guns as soon as may be. We'll talk about bayonets in a second. But by comparison, if you look at these three resolutions, first of all, the town of Danvers resolved that as many companies would be equipped with an effective firearm, bayonet, pouch, knapsack, 30 rounds of cartridge and balls, which means they adopted the Massachusetts Provincial Congress recommendation. And then when you take a look at another one, this is from the town of Lincoln, Massachusetts, which referred to Eric, you can see one of the recommendations for the Lincoln, Massachusetts Minute Company is they're trying to acquire steel ramrods. And then finally, on December 26, 1774, Roxbury ordered militia Minutemen to hold themselves in readiness at a minute's warning, complete in arms and ammunition. And then they go on to define it, including firelock, bayonet, 30 rounds of pouch and ball, and a knapsack. Again, mirroring what the Provincial Congress indicated what they wanted. So the question I often get, where did they get all that stuff? There's this belief like that everything from the French and Indian War was just held over, stored somewhere, and they magically ran the items of equipment. Or there's also this myth that a lot of times willing British soldiers would start selling the equipment to them. When you actually saw it, it was Joel who turned me on to this research, is you start seeing this decentralized logistical support, where you see various communities taking it upon themselves to start producing arms and equipment for the men in their town. And what you actually see is many towns pass resolutions where only single out various skilled tradesmen within their community who will agree to supply equipment. So what you see, for example, is a leather worker could be hired by the town to make cartridge boxes in belting for their soldiers. A woodworker, and again, another thank Eric, when he showed that follow with the cutback stock, there were woodworkers who were being hired who would take fowling pieces, which are stock to the muzzle, cut back, and then they were able to slide a bayonet on. Jonas Parker, who was killed at the Battle of Lexington, he was a woodworker, and in his probate inventory, he has references to musket stocks in there that he was working on cutting down. You can also see people making knapsacks. If you did not have a skill, we have other individuals who are going into Boston, Newburyport, Salem, to buy bricks of lead that are going to be brought back to the community to be melted down for ammunition. So what you see within these communities that took this posture is you start seeing some semblance of uniformity, not in dress, but in equipment. And of course, here are a couple of examples. The town of Brimfield voted that the town of Brimfield would provide for 50 Minutemen cartridge boxes, knapsacks, and 30 rounds of cartridge boxes. The town is going to move forward to provide this arms and equipment for them. This is my favorite quote from Bradford, Massachusetts, which is now part of Haverhill. I found this quote transcribed, buried in a church in western part of Haverhill, where they hired 3 men to make cartridge boxes, belting, and scour the rust off of old French and Indian War bayonets. Yes, there is a small supply of bayonets that are coming in from the old French wars, and gentlemen here are actually making it. And what I found was, of course, nobody works for free. These gentlemen submitted their bill back to the town of Bradford, and the town of the next town meeting voted to allow this equipment to come in. And then Andover indicated their emphasis was bayonets. A lot of communities were trying to get their hands on bayonets. And what Andover does, Lexington does, Methuen does, is they go to the citizens in their town, particularly the older ones, and say, listen, if you're not using that bayonet, we'd like to purchase it from you so we can shift it over to the minute companies. So what you see is actually earlier today where we were talking about restriction on arms. This is an example of redistribution of arms and equipment, where actually the towns are actively trying to shift the best equipment to their minute companies. About things, town of Duxbury, again, voted that they would provide proper firearms and warlike instruments and ammunition suitable to defend your town and country as may require. Lexington, Lexington is a short shrift because they were really ramping up for war. Lexington went out and actually bought a cannon. They purchased a coastal gun. Again, I have to do pre-advertising for John Bell's Road to Concord. He discusses this in his book. There were a lot of coastal artillery pieces and other guns that basically interior communities were gobbling up and mounting on carriages. Lexington formed a committee of woodworkers to mount that carriage. And of course, General Gage is horrified by this. And he puts in an intelligence report in the winter, early spring of 1775, where he says, "My God, they're all armed and equipped." And he lists in there how they're armed with, every man is supplied even to a knapsack, canteen, and blanket, and they're directed to have provisions on the field. This is a neat document that I found when I was writing a research report for the town of Westborough, Massachusetts. I'm very having a brain for it. And what basically this is a real-time document where on the day of April 19th, when the Westborough Minute Company mobilized, they started issuing town-owned hatchets, and of course, as we referenced, gunpowder from the town stock to their men. So again, you see communities who are going above and beyond to provide those arms and equipment. The neat thing, which I'm not sure if this is in Joel's presentation, is the second part of this document, which goes into when they're issuing ammunition for the minute companies, they get down to even the bore sizes of the guns that they're issuing. This one is my favorite document. It's from the Captain Moses Knowles Newburyport Minute Company. It talks about provisions they're providing to their men: cod, biscuit, seed, hardtack. But my favorite one is the last line right above the signature: 65.5 gallons of rum. We're going to war. Quick questions. I wrap up here. There are questions. Did the minute companies and did the militia companies drill? Absolutely. You had drills taking place on the squad level, the platoon level, the company level, and even the regimental level with minute companies and militia companies. The real neat thing, which I also like to talk, if you take a look at the second quote, Cable says we're going to hire somebody to train us in this particular, Crown manual drill. And when I discovered the person's name was George Marston, I always thought that he was this grizzled French and Indian war veteran who was yelling at the teenagers on the field saying, "This is how we did it when we fought the French." No, George Marston was actually a deserter from the 59th Regiment on foot. I have two accounts that I was able to document of British deserters training militia companies in Massachusetts, one down there at the Rhode Island line and Mr. Marston here. And of course, here's evidence from the town of Newburyport, an advertisement where they were drilling. This is in October. So already, as the Massachusetts Provincial Congress is issuing orders for war, towns are already going out. And this is an example where they drilled and they went to a tavern afterwards. Nothing like a cold coalition. You should also understand that in preparation for logisticals, you did have a pay and reimbursement. Communities did pay the minute and militia companies to mobilize for service. And so you see towns such as Bradford was giving dollar for minute billing. And if they had to mobilize for war, they would receive $7 per month when they're out in the field. Acton indicated a pay scale. Methuen established a pay scale. And so basically, this is what goes back to the original point. When I talk about preserving English liberties, I will finish off with basically a quote from the town of Lexington. This is a quote. It actually comes during the tea crisis. So this quote came out actually a couple of days before the Tea Party. But it shows the resolve that they actually have, that they are going to preserve their English liberties. And it's a resolution that says that we trust in God that should the state of affairs require it, we shall be ready to sacrifice our estates and everything dear in life, yea, and life itself, in support of the common cause. Which means for them, their common cause is the defense of their English liberties. And that is why you see that logistical buildup going on. Thank you very much.
Thank you, Alex.
Hey, Alex, quick question. It's fast while they pull up the PowerPoint. How many people were in the average company?
How many people were in what?
The average company.
Excellent. Well, it depended. On paper, the preference was 50. Although I have seen, for example, the Lexington Company, Captain John Parker's company, at the time of the Battle of Lexington, although only half of the company fielded, it was approximately 144 men.
Thank you.
Okay, our next presenter is Jody Madeira. Jody is the Richard S. Melvin Professor of Law and co-director of the Center for Law, Society, and Culture at the Indiana University Moore School of Law. She co-authored the Second Amendment, Gun Rights and Regulation. Additionally, Jody is the leading authority on fertility fraud and reproductive justice. And turn it over to you.
Thank you so much. Ooh, sorry. I'm gonna lower that considerably. So today I'd like to talk about a problem. I'd like to challenge how federal courts are thinking about childhood, firearms history, and the law. Recently, youth 18 to 21 have brought lawsuits challenging federal laws prohibiting individuals from 18 to 20 from purchasing firearms from federally licensed firearm dealers, as well as under some state laws. And they argued this violates their constitutional rights under the Second Amendment. Now, they've gotten a sympathetic hearing from several courts, including the Fifth Circuit, which use historical anecdotes to justify expanding Second Amendment rights. And so the logic, basically, is that if youth fought in militias then, they should have gun rights now. But this is very problematic. As we'll see, it could lead to expanded rights for youth younger than 18. It's based often on bad history. Our ideas about childhood are very different than they used to be. Childhood is not a fixed biological stage, a social construct shaped by adult needs, fears, and cultural contexts. Our contemporary ideas about childhood and the status of children were transformed in the 1800s and 1900s quite radically. And finally, expanded gun rights for 18 to 20-year-olds can clash with other types of laws. So let me start the story. During the War of 1812, a group called Aiken's Volunteers, boys under 16, valiantly fought to defend their town from British invasion, even though they had no formal training. They helped to safeguard a bridge and a blockhouse. The NRA even wrote up the story of their valor in their magazine to commemorate their heroism. But stories like this are often romanticized today, used to support the idea that young people should have gun rights, just as they supposedly did in the past. However, these stories are outliers. They are often the exception and not the norm. Using founding era history badly to define youth rights ignores how much childhood and adolescence have changed, and risks creating legal incoherence with the child protective reforms we rely on today. So let's look how courts are currently divided on the issue. Federal courts are currently split on whether to expand gun rights for those under 21. On one side, these courts base their arguments on arguments that the fact that youths 15 to 18 are part of, quote unquote, the people covered by the Second Amendment, that youth served in militias, and that military service showed adult status and willingness to entrust firearms to youths. These decisions hold that laws passed in 1791 are more important. Laws passed around 1868 are less important. On the other side, cases such as NRA versus Bondi focus on the age of majority, 21, parental control, and the historical lack of youth firearm access. Pinellas versus Lopez recognize evolving societal needs and the scientific understanding of youth development. They also suggest that the constitutionality of federal law prevents 18 to 20-year-olds from buying handguns. Under common law, individuals were infants until 21. These opinions argue they lacked legal personhood, couldn't contract, or needed parental permission to enlist in the militia, etc. These opinions also suggest that they don't have laws preventing youth from having guns in the American Revolution because firearms were expensive, inaccurate, and not used for interpersonal violence. In other words, they only saw these laws come into effect when guns became cheaper, more accurate, and used in urban settings. Cases such as NRA versus Bondi argue that they go back to the age of knighthood, in fact, and they say, well, the age of knighthood was increased to 21, largely because youths couldn't lift a lot of the armor. English law said 21 as adulthood, because of lack of maturity and judgment. They also argue in that opinion that American Revolutionary heroes disparaged minors. They said Thomas Jefferson called youths maniacs and drunkards. John Adams, they said, called youths not fit to be trusted by the public with voting rights, individuals that lacked judgment and will. They also make much of the fact that modern medical science shows that the brain matures around age 25, that youths are more vulnerable to stress and risky behavior, that individuals did not need gun laws until new industrial advances incentivized people to move to cities to work, that new firearms became cheap and more accurate, so they became easily usable and available for crime. And finally, these opinions mention that laws prevent sales to people under 21, laws preventing sales to people under 21 have gone unchallenged for almost all of recent history. So we looked at one recent case, Reese versus BATF, brought to the Fifth Circuit in January 2025. Here, Judge Ian Jones raised three key arguments: that purchasing firearms is a corollary act necessary to exercising individuals' Second Amendment rights, that individuals 18 to 20 years old were part of quote-unquote the people that were included in the political community, and that there were no age restrictions in the Second Amendment's text, that the 1792 Militia Act requires males 18 or older to enroll and arm themselves for service, and that the 19th century laws restricting youth gun access were really passed too late to matter. So she's focusing on the core laws being passed in 1791. On the other hand, this is Murray versus Bonney, completely different picture in the founding era. Individuals under 21 were considered infants. They lacked legal persons who could not contract. Parents were required to provide weapons for militia service, and they argue minors didn't own firearms independently for that reason. And of course, we have the founding fathers that disparaged minors and expressed concern about their lack of judgment and prudence. But what's the real history behind youth in militias and military service? So many courts claim that young teens commonly served in militias, and that justifies or should justify gun rights for today's youth. But the reality is more complicated. Boys did serve, but they were the exception and not the rule. Under this US Census, productive youth, quote unquote, 16 and over, were distinguished from dependent children. Males between 16 and 21 were considered to be in a liminal period where they were supposed to gain training to be full adult citizens. Eligibility to serve was considered to be different than a tradition of frequent service. Most militia members were older teens or adults. Younger boys were rare and usually served as musicians or in support roles. Very few were under 16. So, for example, we have 2.4% serving in 1777 in Massachusetts muster roll. We have 1.6% from Morris County in New York. I'm sorry, I think I might do the wrong slide here. There we go. And we have 2.2% at the Battle of Kings Mountain in North Carolina. So overall, 30 to 40% of adolescent males saw militia service in some capacity from 1740 to 81%. However, that doesn't mean that they served in combat roles. So we saw that youths also fought for a variety of reasons. So I think I might be on the slightly wrong slide again. We had a number of different reasons. I mentioned before that English law had raised the age of knighthood to 21 because armor was very heavy. This continued in the American Revolutionary era because muskets weighed about 15 pounds. That was far beyond those children's capacity. Young boys were seen to lack the stamina for long marches, and officers really resented altering companies' pacing for young boys. Officers, in fact, worried that mere boys, altogether incapable for sustaining the fatigues of a soldier, were incompatible with militia service. This was also true for the British Army, where Bennett Cuthbertson considered young boys quote unquote useless and considered recruiting them a fraud on the public. So it seems that all forces preferred recruiting mature soldiers when they could. When boys did serve, they often did so in non-combat roles. Several served as drummer boys, constructed barracks and other camp facilities, guarded stores and prisoners, carried supplies and messengers, and cared for the wounded. So this actually leads to a bit of a slippery slope problem. Although enlisted statutes allowed youth as young as 15 or 16 to serve in groups like the Posse Comitatus, or groups of citizens summoned by a sheriff to help with law enforcement to keep the peace and apprehend criminals, much younger children often were parts of the militia as well. often ages 10 to 13. So what's the limiting act, the limiting age, if we're going to use militia to argue that that sets the bounds for gun rights for youth? So although the 1792 Militia Act raised the age for militia service to 18, we see historical service. If historical service, determines constitutional rights, then the logic for expanded firearm rights inevitably extends downward. Judge Edith Jones on the Fifth Circuit acknowledges this concern in Reese versus the ATF, but offers no clear limiting principle. So if the historical picture is more nuanced, how has the very concept of childhood changed since then? As we see, childhood was very different in 1791. Children were first seen in medieval ages actually as sinful, deceitful, weak, and frivolous. On American rural families, the children were laborers, security for aging families. The birth of a child was seen as the birth of a worker. Children worked and lived alongside adults. They had no independent spaces of their own. Childhood was a period of life that was seen as one that was brief and should be ended abruptly. Alexis de Tocqueville famously said, in America, there is in truth no adolescence. But that was to change in the 1800s and 1900s. Childhood is a social construct, as I said earlier, that has changed dramatically since the 18th century. When children moved as an object of utility to an object of sentiment, they became economically useless, but more emotionally precious. So in saying goes. Childhood became a life stage to be enjoyed and prolonged, a nurturing period that required separate space, tools, and toys. This was enabled by an economic shift from an agricultural to industrial society, declining birth rates, parents could focus on fewer children, and some laws, legal changes like compulsory schooling. So between the 1870s and 1930s, America also underwent one of its most striking social transformations, which was the removal of children from the workforce. In 1870, 1 out of 8 children were employed. By the 1930s, childhood labor was practically eliminated. Opponents had argued that work built character and prevented children from becoming quote-unquote paupers and thieves, but the reformers won. So compulsory education laws and age-based employment restrictions gradually destroyed the class divide between middle and working class childhoods. We also saw legal and scientific advances, including developmental psychology, that helped to put in place a host of social changes. Pediatrics, an entire new specialized medical field focusing on children and their unique needs, evidence-based research on children that informed education and juvenile justice, developmental psychology, and neuroscience. Of course, this had a lot of repercussions for law. It helped us reform our court systems. We put the best interests of the child standard in place in family law. And in education law, we saw the advent of compulsory schooling and prolonged residency with the family into the 20s. So these legal changes have been recognized and reaffirmed in various Supreme Court rulings, such as those banning the juvenile death penalty and life without parole for juveniles. Thus, an 18-year-old in 1791 is very different than an 18-year-old in 2025. In 1791, we had a brief childhood ending abruptly. In 2025, we have an extended childhood into the early 20s. 1791, economic necessity drove early work. 2025, extended education and development prioritized overwork. 1791, no childhood spaces that were separate. 2025, a great deal of separate spaces. 1791, limited education and mostly practical training. 2025, legal recognition of ongoing brain development. Firearms have also changed. 1791, they were expensive, inaccurate, and rarely used for interpersonal violence. In 2025, they're readily available, accurate, and lethal. As Saul Cornell has argued, the term young adult was decidedly anachronistic for the founding era. There was no legal category of young adult until the latter half of the 20th century. Thus, expanding Second Amendment rights for 18 to 20-year-olds based solely on 1791 history can create internal coherence with the vast body of modern law that recognizes youth as a distinct category requiring special treatment. Criminal law recognizes diminished culpability and bans harsh punishment for youth. Contract law limits binding agreements for those under 21 due to lack of judgment. Family law prioritizes child welfare and recognizes extended dependency. Education law mandates schooling based on developmental needs and stages. And so law asks a problematic question. How can we simultaneously recognize that young people supposedly lack the judgment for certain judgments while granting them unfettered access to certain weapons? So, given these changes, what are the problems with using a history tradition test to decide youth gun rights today? and basing 18 to 20-year-olds' firearm access entirely on the militia. First, there's a slippery slope. If militia service is the basis for rights, why not extend gun rights to 16-year-olds or even younger? This undermines modern protections for youth. Second, there's a false equivalency. Equating 18-year-olds in 1791 with those in 2025 ignores dramatic changes in youth roles, legal status, and societal expectations. Third, there's legal incoherence. Expanding gun rights for youth conflicts with other child protective laws creates contradictions in the legal system. Justice Jody Madeira has cautioned in her opinion that precedents were not meant to suggest a law trapped in amber and emphasize the importance of principles that underpin our regulatory tradition. A narrow focus on 1791 to support firearms rights for 18 to 20-year-olds fails this test. It misreads historical facts in context. An absence of regulations in 1791 reflected different conditions, not a prediction of unfettered youth access to firearms. It ignores societal evolution, childhood technology, urbanization, and societal structures have all fundamentally changed. It dismisses scientific knowledge. Decades of medical and psychological research on child development, neuroscience, and capacity would be rendered irrelevant. Finally, it creates unnecessary legal contradictions. It conflicts with legal reforms across criminal, family, educational, and tort law based on protective, modern understandings of youth development. Thus, history is important, but so is understanding how much we and our children have changed. Courts and policymakers should recognize the profound transformation of childhood and adolescence and avoid simplistic historical analogies when adjudicating youth rights. It's not that we shouldn't give 18 to 20-year-olds firearm rights. It's why. Thank you.
And our next speaker is Joyce Malcolm. Joyce is the Patrick Henry Professor of Constitutional Law and the second professor emerita at the Antonin Scalia Law School at George Mason University. She's a leading historian of individual rights, including firearm rights. Her research and commentary been featured in major law reviews and national media outlets, and indeed in Supreme Court cases as well.
Just as started is not important. The start of 1791 was the date they set. It's the date that the Second Amendment was approved and the understanding that people had for it. And what I'd like to do in talking about militia is to discuss the issue of the militia against what they call standing army, professional army, because I think that you need to understand the attitudes then and the balance that people were trying to hold on to between a citizen militia and professionals, and something that affected our Constitution and also the language of the Second. The idea of the citizen militia had been something that was really important to the English tradition for what the common law calls time out of mind. They always depended on a citizen militia. 1660, people were, even poor people were to supply weapons to this militia. People were very poor. A group of poor people would get together and pay to supply a weapon, even if they couldn't afford one on their own. The idea for depending on that was that your citizens in the citizen militia were your neighbors. They would never harm you. They knew you, they spoke your language. whereas foreign mercenaries and professional soldiers had other attitudes and priorities. So you could always depend on the citizen militia, and it was a way, in fact, of keeping control as opposed to yielding to what the crown might do. They really resented the ideas of mercenaries or professionals coming in, hired by the king. And in fact, during the 16th, 17th century, many of the countries in Europe had lost their freedom because their kings had hired mercenaries who were there to suppress the people. And I think it's interesting how many countries today have been taken over by their own army, and whoever was in charge of that army puts on a civilian uniform, and there he is as the head of the government. So I mean, they were really worried about this, and so they depended on the local people, and really going even back to Magna Carta, and I won't go through all the instances, but in 1214, King James had to promise to send away his foreign mercenaries. So there was just this innate feeling that you needed the local people, and also the local dignitaries were very happy to have some kind of make-weight against the crown. If the crown wanted to go to arms to a war against another country, he had to raise the troops just for that, not use the militia. The militia were local and not under his control in the same way. During the 1790, the period right before the American Revolution, William Blackstone, who published the Commentaries on the Laws of England, was one of the most important writers and influences on our founders. And this is what he said about having a state, what they call the standing army, professional army. He said, in a land of liberty, it is extremely dangerous to make a distinct order for the profession of arms. He advised Englishmen to look upon their own professional soldiers, and they had some, as temporary execrances bred out of the distemper of the state, and not as any part of the permanent and perpetual laws of the kingdom. And just as an example of how suspicious they were about the army that then would give them this wonderful empire around the world, the army had to come back to Parliament every year for its budget to make sure it behaved. The Parliament could always renege on that. They had to come back every year for the budget until after World War I. So there was this really deep-seated feeling that it was very dangerous to have an army in a great country. On the other hand, there are some real problems with militia. And I'd like to go into these, and then we'll see how it all plays out. The militia in England, and it's somewhat different in America, but militia in England was county-based and always defensive. And there's an example of this as a problem during the English Civil War in the 1700s, where in the king's, it's the king against Parliament, where the king's general, Rupert, a nephew of his, was leading a band of militia. They got to the county line, and they would not go across the line. He got the first person in line, and he put a gun to the guy's head, and he said, cross that line to the next county. At that point, all the other members of the militia sat down. They would not be a standing army. They would not leave home. They were strictly defensive. And it's one thing actually that occurred to me in thinking about this, that the American militia is different, because the American militia does go from one county to another. During the French and Indian War, you have the Connecticut militia going to New York, and later on, the militia doesn't seem to have any problem at all. So there was a kind of unity that they didn't have in England. But at any rate, part of the militia tradition from England and to America is that you supply your own arms. And in early America, of course, there were laws that required that people supply their own arms. In Massachusetts, in Connecticut, in Virginia, householders were to be armed and were to supply arms to people in the field. Now, some of the problems with the militia were that they wanted short enlistments. They were not there for the duration of whatever the war was. They had short enlistments, they brought their own weapons. Sometimes they needed more supplies. They were not disciplined in the same way. And as we've heard, Massachusetts went to a lot of length to try to get some proper discipline. Even when the militia in England and the militia here had regular times when they drilled, sometimes it ended up being more party, or people felt like, as you said, they went out to the tavern. So there was it lacked that kind of seriousness. And so when it was really necessary to have a more serious militia, they needed to reduce the ages and have it sort of 18 to 40 group instead of 16 to 60. But 16 to 60 was the tradition. And in fact, during the war, there was a lot of problem with militia retreating until they got special training. There was also a problem that they only were willing to fight for short periods. And so Washington was really in despair. He had to depend on the militia. Congress was really reluctant to give him an army. I think we need to remember that. They were very reluctant to have a profession of arms, even one that they controlled. They remembered the English experience with from that same English Civil War with Cromwell, the leading general, taking over and throwing Parliament out and ruling the government. He was the general of the army. So they didn't want to do that. He didn't. I always find it interesting that you got the same group of aristocrats in America. And during the war, half of them go into government, Congress, or local legislatures. The other half go into the military. And the ones that go into government worry about the ones that go into the military. But they're basically the same people. They just, took different routes. But there was this ancient tradition of being anti-army. Washington was really, really in despair because they had short enlistments, and just when he needed them, they were ready to go home. And one of the reasons, you probably know that he crossed the Delaware when he did was right before Christmas, because if he didn't cross it that day, a good part of his army was the militia were going to go home. Their enlistments were over. Here was else was looking on. So he writes a letter to Hancock, who's the president of the Congress, pleading for an army. He said it's a melancholy and painful consideration to those who are concerned in the work and have command to be forming armies constantly and to be left by troops just when they're about to deserve the name, or perhaps at the moment when an important blow is expected. So Congress did have an army. We have the first aspects of the Continental Army, although they were still pretty careful about how they organized it. At first, they did not want any slaves in the army because they felt that an army that was fighting for freedom should not have slaves. But they eventually did. And one of the reasons was that in the South, the British were offering slaves who came into them freedom. And so there was real worry that if they didn't include these people, and they were good fighters, and they had been there early on, as you've heard, then they would go over to the British. So, and they also needed people. So they had armies that were of mixed race, and it was the last time, as many of you probably know, that the African Americans and whites fought side by side in an integrated army until Truman integrated our army. Pretty disgraceful. But at any rate, that was the way that the army worked. However, the army was kept on a very short leash, or at least Washington was. He didn't have the freedom to promote people unless Congress did. Congress still votes on who gets promoted. But Congress also had the very nasty habit, as far as Washington was concerned, of inviting these wonderful soldiers of war or to come and have some high rank in the American Army over a lot of the national Americans who have been fighting. So you got some of them were very good, obviously, important to us, yeah, stupid. But there were others who were just a nuisance that came over and lorded it about, and they weren't Washington's choice. And at one point, Washington actually refused to resign because more of this happened. But he was a very patient man, happily for us. He did not resign. At any rate, there was a lot of trouble raising these people, and bounties were given to get people into the army. And African Americans or people who were slaves, especially in Massachusetts, where there weren't many, but they were given the option if they joined the army that and fought for 3 years, they would be free. And sometimes people hired people to be substitutes. I remember one slave man from Mexican who joined the army, and afterwards he changed his name. His name was Jupiter, first name, to Jupiter Free, which for some reason the local historian had interpreted as tree. I thought, no, this is Jupiter Free. He's just really proud to have been able to do that. The army and the Washington managed to get together, and the militia coexisted side by side. And I thought that wonderful example that we heard about Shays Rebellion was a good example of the problems that you would have between the two. One of the real problems with the militia is that they're your neighbors. That was an advantage. But when there was some rebellion going on, you couldn't trust them to actually put it down because they did not want to. They might side with the people who were doing rebellion. So there was this need to have an army, whether they liked it or not. When it got to the Constitutional Convention, there was some real doubt about what to do. I mean, there were some members of the convention who said that they had been making an experiment depending on militia, and this wasn't going to work out. We needed, we had to have an army, and we did eventually have one during the war. So we needed to make some provision for continuing the army. And also, of course, you had a frontier. There needed to be somebody guarding the frontier. You couldn't have a militia to be doing that. And then there were others who felt that this was really too dangerous. They worried about Blackstone's comment about a land of freedom shouldn't be dependent on professional military people. And one of those who began to have serious doubts was James Madison. He near the end of the Constitution, he was always coming up with additional things. He began to be worried about the amount of power that the federal government would have if they gave them an army. Also, the army's budget wasn't to be every year, like in Parliament, but every other year. So he began to worry about this. And his suggestion was that there be an army created, but that there be a limit to the number of people that could be in it. And his idea was 3,000. 3,000 people, 3,001, that this would be part of the Constitution. But at that point, people were tired, it's practical, and they left it. There were issues about whether they wanted to say something against having an army in America, in the Constitution. And there were a lot of members who thought this would be unfair, dishonorable to those people who fought and who were part of the army, and we might need an army. And so what they did was they left the clauses for an army, always, of course, with civilian control over it. But I think the language of the Second Amendment comes close to trying to show their view without insulting an army. So the Second Amendment talks about the well-regulated militia being necessary to the security of a free state. And I think that they put that being necessary because that was the way of not designing an army, but it was showing that we needed to have a militia as a sort of bank. We went ahead and had an army. Unfortunately for those members of the Continental Army, they were often in our textbooks and other places called the dregs of the society, and really unfair. They suffered something like 30 to 40% of the casualties during war. But I'd like to just include with Washington's address to those people who were the final members of his Continental Army. Many of them had been dismissed in June, and that final group came down from the Hudson Highlands and started heading home in the wintertime. And this is what he said in his address to his men in the army. He talked about those, they were references those he held most dear. He recalled their unparalleled perseverance through almost every possible suffering and discouragement, and marveled how men from such different parts of the continent had become, quote, unpatriotic beyond the brothers. Who, he asked, will exclude them from the rights of citizens and the fruits of their labor? He recommended them all to their grateful country and prayed, quote, to the God of armies, that they who had secured innumerable blessings for others might find justice here and heaven's favor hereafter. I think that the government, our Constitution, has done a good job of trying to give us both a well-regulated militia, both the right to protect ourselves and our families and the country, and also to have an army to be there all the time when we need it and make sure that it does not end up supplanting the civilian government. So thank you very much.
I'll start us off with a couple of questions here. Sir.
If I may ask the professor, would you compare the militia of the 17th of the Second Amendment to the National Guard of today? Are they the same, analogous? Yes, please. Is one more of a standing army than was conceived in?
Yeah, unfortunately, the militia has been made into the National Guard, which is under the control of the army, which is under control of the government. So the very idea that it's a sort of make way to the army has no longer holds in that sense. That although the National Guard is still a kind of home-based force and a state-based force, so you're right. It's a good question, and it's maybe it's hard to keep that whole balance, and we don't distrust our standing army to go off and take things over, but that's what happened to the militia. Although there's some states that have what's the unorganized militia, and I believe that South Carolina actually has a uniform for members of the unorganized militia. Should they ever want to use those? Oh, defense. Yeah. Right. Oh, thank you.
So in the context of when the Second Amendment was drafted, in that context, the National Guard, as we know it today, am I correct, would be much closer to a standing army than to the militia as understood at the time of the drafting of the Second Amendment?
Yes, I think you're right. The other thing is that they made a distinction between what they call a select militia and a more general militia. Select militia, a smaller group of people could in some ways be a standing army. But they went with the idea that everybody was to be part of the militia, the general public.
The select militia, one thing worth adding to that is they were typically on the king's payroll or on somebody's payroll and worked for that person basically full time and relied on their livelihood for that. And that made them look, as both of you are saying, very much like a standing army as opposed to a civilian force like Alex described. So I'll start us off. I guess I won't start us off, but I'll continue the questions with one I had for Alex, or I guess maybe a two part one here. Is have you found any documentation or contracts or covenants or records or diaries or anything, documentary, paper documentary, or something like that, evidence of men in Massachusetts tying their militia service, broadly understood, they'll call it service, to a defense of their rights as Englishmen, that being kind of the motivation behind what they're doing. And then I just had sort of maybe this is related, maybe it's not. What are the differences between Minutemen, militiamen, alarmist companies, and other kinds of government peacekeeping? Sort of semi-government, semi-civilian peacekeeping.
So I'm reasonably going to be sarcastic and just simply say yes, but I'll answer the question. The answer is yes. In my analysis of looking on the eve of Lexington and Concord, particularly either with town resolutions or Minuteman, I'm just going to call them Minuteman covenants. Town resolutions, for example, Lexington, Andover, Worcester are all replete with various resolutions where they either specifically say we are defending English liberties or they're invoking English liberties into covenants. And with the town resolutions, excuse me, I got ahead of myself. And so I do see either one of two things in the town resolutions. Either they specifically broadly sense English liberties, or I actually see another phrase, charter rights, where they're referencing the Charter of 1691, where they wanted to defend these charter rights. And keep in mind, the modern analogy of the three of us, and these two ran circles around me, if I give a brief modern analogy, the revocation of the Charter of 1691 would, in the Massachusetts mindset, would be taking the Bill of Rights today and putting a match to it. This is the mindset of Massachusetts at this time. When you look at particularly the Minuteman covenants and the independent companies, which I'll talk to you about in just a second, the Minuteman covenants generally had 3 to 4 clauses in their covenants. First of all, we're gonna drill. These are the arms and equipment we're going to have. We're going to treat it as a military operation or military training. But usually most of the covenants start off with a purpose. Why are we doing this? And they say we have to defend our rights as Englishmen, our lives, properties, and privileges as Englishmen, our charter rights. So I've seen multiple towns through this. I'd say about almost at least 30% of the documents that I've collected within this period, I see some form of invocation of English rights. Now, to get into the various structures of the organizations of this time, buckle up. It's basically 3 to 4. Your militia companies existed as far back as probably about 1628, 1630 in Plymouth Bay Colony, in Massachusetts Bay Colony. At that point, to touch upon what Jody indicated, it was anyone between the ages of 16 and 60 were required to serve in a militia company. Militia company established laws what you had to field with, what you were, the type of muskets you were supposed to have, the type of sidearms you were supposed to carry, etc. Basically, in theory, every town was supposed to have at least, in Massachusetts, every town was supposed to have at least one militia company. However, as towns grew, and we talked yesterday about we're in Andover. Andover is a perfect example. I grew up in North Andover. Jody may have passed through Andover in a brief time. That was one massive town. And as the town got bigger, they initially divided it into districts. So you had 2 militia companies. So as the town got even bigger, it broke into 4 districts. So you then had 4 militia companies. There are subsets of militia companies, which basically the first is what's called an alarm list. An alarm list today, I would qualify for an alarm list, finally. Alarm list is your reserve forces. Usually, and this was actually an 18th century construct. I really don't see in the 17th century the creation of an alarm list. It's more of an 18th century construct, where these are individuals at first who are 60 or older, who would be required to the field in times of a dire emergency. Lexington and Concord is a perfect example of that, because I have accounts of multiple alarm lists at the fight at Menominee, which is the bloodiest portion of the day. Captain Caleb Kingsbury's company was an alarm list company, and they took 3 casualties, engaging in brutal fighting with their enemy. I start seeing on the buildup in 74 to 76, the reduction of the age of the alarm list down to 50. Of course, I'm fortunate to qualify. So I do see that taking place. So it had been a real true emergency for alarm lists to mobilize. I then see what's referred to as independent companies. And if you think of the American Civil War, when you start seeing these elite light infantry companies or these elite artillery companies, they actually existed during the American Revolution. The town of Newburyport at the time actually had three independent companies: an artillery company, a quasi-marine company, and then a foot company. And these were all part of ship captains, ship owners, merchants. Usually with the independent companies, I saw for Massachusetts more of the more elite doing it. And some of them have really, really neat uniforms. They have some great uniforms that I've got some vague descriptions of. Haverhill had a elite artillery company. They couldn't find a cannon that anyone else bought them. So they said, we're going to become an independent midnight company. And then in preparing for the eve of Lexington and Concord, they actually sat down and had a meeting to discuss what are we going to wear when we go to war. And they had this exquisite uniform that they never made, but it was really neat to see. But the final thing I want to say, which sort of was touched upon today, I think it is, from my perspective, with the role of militias in Massachusetts now. Don't ask me about Virginia, don't ask me about Pennsylvania, because I'm strictly a New England guy. But the roles of militia, particularly for 75 onward, and it is also, I saw it during the French Wars, it's a lot of times over a recruiting pool. Okay, that became predominantly their focus. So when we were looking for war with England in 74, 75, Massachusetts had to take this body and convert it from a recruiting pool into a cross-the-board fighting force. So I know that, but I appreciate it. I can talk all day about militias if you like.
Before the militia.
So what would happen is basically, let's take the French and Indian War. What would happen is a recruiting officer, usually a Massachusetts provincial who is appointed a colonel, would then go to I'll be blunt, to a lot of his buddies and friends and relatives, as often is the case in Massachusetts, and say, all right, if you recruit X number of people, you will get this commission. And what they would do is they would then, it's almost like a giant pyramid scheme, they would work their way in, eventually coming into Lexington, Concord, Andover, and say, I am looking for a X number of troops. And what would happen, and Fred Anderson in his book, A People's Army, discusses this. A lot of times it was the youth that they were targeting, more closely about 1821, because they need money to buy land. And what they're finding is they're then serving for a year's service, and they're getting a higher rate of pay than their British counterparts again. But to address what you had mentioned, Joyce, during your discussion with these recruiting pools, they're provincial regiments, but they're temporary. Usually the term of service for French Indian War was about a year. When you get into the Revolutionary War, there's this conversion of all those troops around Boston, oversimplifying into this Massachusetts Grand Army. Again, they follow that provincial tradition of a one-year service. But for examples like Saratoga, the Trenton, Saratoga, the New York campaign, you had militia companies only serving for 90 days. So it's very short term. So that's where the recruiting pool actually comes from. And then my limited knowledge of 19th century militia, you see the drop of the town militias and more of the rise of the independent and state sanctioned militias, which I think gets into the National Guard discussion that takes place in Massachusetts.
So we have time for one more super fast question and super fast answer, hopefully. Sorry, you might hear hand up.
I have my questions for Jody. Great presentation on the 18 to 20-year-old. I had a question in there on the historical application at the time versus like the way the federal law is now, where it's very bifurcated, and 18 to 20-year-olds have full rights with respect to rifles and shotguns, and only restricted or infringed on handguns. And even to further parse that out more, it's only the purchase from an FFL, and there's no restrictions on ownership or carry. How does the militia period affect that? Was there a bifurcation at the time? And then I guess the final wrap up of that is the position to maintain the status quo or to move all firearms out of 18 to 20 and set the new age at 21?
So I'm not aware of any bifurcation at the time. I think that you had the traditional, not on the basis of age, at least. I think you had the bifurcation based on lethality or criminality of weapons. You had the DAGs, you had the pocket weapons, you had the military weapons that were perceived as dangerous, in other words. But those were forbidden for everybody, not just on the basis of age. And those were also the Bowie knives, etc. But I think a lot of those regulations, I'm not aware of any age-based restrictions on those. They were sort of just uniformly.
Yeah, yeah.
Lit.
I did a little research on this and, I could find by other people whose research I looked at, you know, in doing my research, found a total of 20 altogether in our history, restricting based on age. Which is not a lot, which is kind of a small amount. And most of them, were just various kinds of transfer restrictions, like, you know, your parents could get it for you, or you couldn't buy one, but someone could get one, give one to you, this kind of thing.
Exactly. And just, you know, to the latter part, I think that it's always somewhat silly that we have these restrictions on handguns when, in fact, in most states, Indiana included, 18 to 20-year-olds have full reign, as you noticed, with respect to long guns, which includes ARs. And I don't know why we're so restrictive as to handguns. And so to me, it's just incoherent to do so and to be so restrictive on the basis of history, you know, when there are so many other ways that we could make analogies to historical principles. So I think that we need to evolve beyond that English comparison. But that's an excellent question.
That's assuming that our constitution is supposed to evolve.
Yes, well, theoretically, we're not trapped in the emperor. Right.
All right. Well, with that, let's thank,